Good morning. Thank you for having me. My name is Braham Siegeal. I'm almost 50 years old. I've been doing family law now for about 23 years. Some people tell me I need to have more gray in the temples, but it's been a long time. And I do a lot of litigation, negotiation, marriage contracts, appeal work, and I also do a fair amount of collaborative, and in the last 10 years, an increasing amount of mediation and arbitration. When I was here about 9 years ago, was it that long? I did a kind of round the world in family law in 60 or 90 minutes. Today I'm going to leave you as specialists in property law. I'm not going to talk about spousal support, although I am going to answer questions. I'm sure we'll have time for some questions. I'll answer questions if you want about spousal support. But my goal today is to make you specialists in property law. Why property law? Because I find that with non-lawyers, and I include in this category divorce coaches, non-lawyer mediators, financial professionals who didn't go to law school, it's the one area where we see the most amount of errors, misconceptions, false beliefs, and so my goal to you today is to add value with that. Why don't we start with the easy stuff? When people come in for a consultation with me, I try and give them like a 3 or 4 minute primer on property. Your primer is going to be a lot more detailed. I understand I have 90 minutes. I don't intend to use all of it, but and feel free to poke in a question or two every now and then. But my goal is to give you a template, something that you can work with when you are working with clients, so that you give them a really good understanding of how the law really works. And when I say really works, let's start with the basics. So when we talk about property law, first of all, every province has its own rules for property law in Canada. And this surprises a lot of people who come to the office because they think that divorce is federal, which of course it is. So in Canada, we have things in family law that are the same province to province, like divorce, like child support, like custody, and some things that are province by province. Well, how does that work? It's by virtue of our Constitution, which says that certain things are determined by the provinces, and property is one of those things. So I always tell my clients, and you should do the same, that if the client is doing research online, which increasingly we see, tell them to make sure they're looking at Ontario. That's the first thing I always tell them. So in Ontario, a lot of people think we just divide property by 50-50, half. How many of your clients come to you and say, well, I know property, I've already done my research, it's all half? How many people get that? We get that all the time. And people always sit up straight and their heads kind of snap back when I say, anyone who tells you that doesn't know what they're talking about. That's completely and utterly false. We do not just take half. I always tell people, much to their surprise, you should see their eyes bug out. You're not entitled to half his house. And they're like, wow. And she's not entitled to half your pension. Oh, okay, good, I'm so glad. But they have no idea where this strange disconnect comes from everyone in their life telling them that their spouse is getting half, and me just telling them that's not how it works. So how does it work? Anyone know? In Ontario, we have something called equalization. And equalization is a fancy legal term for a money payment. That's all it is. It's a money payment by one spouse to the other. There's no tax on the equalization payment. It's not like spousal support where it's taxable and tax deductible. And I always tell clients, and you are free to crib this from me, that a really easy way of understanding how equalization works is like a camera that takes a picture. Okay? I think I jumped down to number 5 on that. We take a picture. What does that mean, we take a picture? So we take a picture at two different times, 2 different points in the parties' lives. Any idea what those 2 dates are? Very good. So we take a picture. And the picture that we take is not what you are wearing, not what you are doing, and definitely not what you're earning. That's for support. The picture that we take is what each of the parties are worth. Assets minus debts. And we take this picture at 2 different points in time, date of marriage, date of separation, not because it's fun, not because it's a lawyer make work project, but because the law says, and by the way, what law are we talking about? Very important for you to know this. Which kind of law? Not the Divorce Act, because that's federal. Family Law Act, good. So we take this picture because the Family Law Act says you have to look at the increase from marriage to separation, which means we don't really care so much along the way what happened up to marriage with your net worth, and we really don't care what happens to your net worth after separation. we care about date of marriage and date of separation. And by the way, date of separation. Who can give me a good definition of the date of separation? Because it's something that also people frequently misunderstand. Who wants to give it a shot? I'm not taking marks. This isn't being recorded, at least for me. Sharon, what's the date of separation?
The date when you felt that the marriage could no longer continue.
Okay. Anyone want to add to that?
It's the negotiated date that both parties agree to.
The negotiated date. Okay, can be. A lot of people think it's the date that one person leaves the house. It can be, but it's not the definition. A lot of people think it's the date you hire a lawyer. Can be, but it's not. A lot of people think it's the date you start a court case. Likely not. Okay? The date of separation is the date that one party makes it clear to the other the marriage is over. So in your head, you might think the marriage is over, but if there's some sort of proof, that's really going to be the better indicator. So whether it's a Dear John letter, sorry, John, I don't love you anymore, I'm leaving the house today, and you leave the house that day, that's your date of separation. But for most people, it's the date when one person says to the other, this isn't working anymore. We've been to counseling, we've been to therapy, it's just not working for me, I'm not feeling it anymore, I want a divorce. And the date that they get the letter from the lawyer or the date the court case starts, that's not your date of separation. The date of separation is important, as you understand, for equalization purposes. It's also important for a second purpose. Anyone? 1 year from that date, you can get a divorce. You're all divorce specialists, so you should know that. So 1 year from the date of separation, you can get a divorce. Doesn't mean you can't start a divorce case the day after separation, and many of my clients do start a divorce case in court the day or 2 or 3 after separation, but the earliest a judge can sign it is 1 year after, unless there's been cruelty or adultery. Cruelty or adultery can get you a divorce before the 1 year is up, but 99.9% of the time we just wait for the year because it's easy and because you don't want a judge thinking that you're just turning someone's crank by asking for a divorce based on adultery. That's what a judge will think. So 99.9% of the time, even in cases of adultery, in a lot of my cases there's allegations of adultery, we just wait for the 1 year. Okay, so date of marriage, date of separation, your net worth. So we look to see what the increase is in that net worth. And we look to see what that increase is in terms of raw dollars, not percentage. And if both parties increase their net worth the same amount of money from marriage to separation, what happens? Nothing. They both go their separate ways. So even though your pension may have increased by $200,000, if your overall net worth increase is the same as your spouse's, no one gets anything from the other. So that's why it's very important not to tell people that they get half of the other person's asset. We don't chop up each asset. So most of my cases aren't so simple. Most of my cases, the parties do not increase their net worth the same amount of money. Usually during a long marriage especially, both parties increase their net worth, but usually one person increases their net worth more than the other. Because at separation they have assets that this person doesn't have. Or it could be that at separation they both have the same amount of assets, but this person has more debt. And if that happens, if there's a gap between both parties' increases, what does the law say about that gap? You have to share it. You have to share the gap. Why? Very simply, why do we share the gap? No. We share the gap because marriage is a partnership, according to the Family Law Act, at least until separation. So whatever that gap is, it has to be shared. And the way it's shared is not by chopping up assets or even transferring assets. The gap is shared with this money payment that one person makes to the other called an EP or equalization payment. And that's it. Simple as that. The equalization payment can be made in a number of ways. It can be made by writing a check. It can be made by transferring money from one person's RSP to another, tax-free. Most of my cases, the equalization payment, which is usually large, is usually made when a house is sold. If the house is in joint names, from one person's share of the net proceeds goes to the other, a chunk. I always tell people that I think they get it. So I say to them in my office, I think you understand what I'm saying, but I'm going to give you a really simple example to make sure it's concrete, because studies show that the different ways we learn something, the more it stays in our neurons. So I always give people a very simple example, and I watch Some of them get it and answer, and some of their eyes glaze over, and that tells me they don't understand equalization, so I go back and kind of fix it. So, example I frequently give is a case where during the marriage the husband increases his net worth by $100,000. And I make sure to tell them, I say, look, at the date of marriage the husband could have been worth 0, and at separation he's worth $100,000, or he could have been worth $1 million, and he went up to $1.1 million. The key is the growth. I even do this with my fingers. I'm so used to doing it 5 times a week for like 23 years, I can't stop. So I say in the same example, let's assume the wife increases her net worth by $80,000. So if she's gone up by $80,000 and husband's gone up by $100,000, what's the gap? Most people get it right. They say $20,000. And then I say, okay, so how much would he have to pay her to make life equal? And I do this with my hands. And most people say 10. I say, perfect. You just saved yourself 3 years of law school. So if he paid her 10, he would come down to 90, and she would get 10 going up to 90, and that's it. That's how property is done. And that's the 3-minute primer. You guys get a little bonus. You get a lot more detail than that, because that is, of course, the simplified version. A couple things I don't want to make sure I don't forget. When we're talking about property, what is property? People who are not in family law typically think of property as just real estate, and it's not just real estate. It is shares in a business, shares in a corporation, private shares, shares in a public company, bonds, warrants, restricted stock units, furniture, pensions, interest in a trust. Those are all considered property. A very important concept, number 7, when we're figuring out equalization and we're listing everyone's property, is the difference between legal and beneficial ownership. This comes up all the time in family law. Okay? Because before you can determine the equalization payment, you have to figure out which property goes on which person's side of the ledger. Because this is kind of the opposite of real life, I always tell people. In real life, you want to convey that you have a lot of property and very little assets, so people think you're great. But in family law and equalization, it's the reverse. You want the other guy to have the big increase, and for you to have a lot of debt so that you have a small increase so that they owe you a lot of money. So things get really weird in family law with people trying to say, I don't own, it's someone else's property, and I have all this debt. And that's a lot of the work that we do, trying to uncover assets, trying to show that this person had this asset, or that my client doesn't have this asset, or that it's really a significant debt for my client or not a significant debt for the other side. Opposite of real life. So frequently, and the Court of Appeal has made it clear, the first thing you do before figuring out what the equalization payment is you figure out what are the assets and who owns them. So we often get into this business about, I don't own. He owns. She owns. My mother-in-law owns. My father-in-law owns. So a very important concept for you is the difference between legal and beneficial ownership. Legal ownership is whose name is on the paper. Right? So if I buy a condo and for whatever reason put it in my kid's name, he's the legal owner. Beneficial ownership is who really owns the property. What are the indicia of beneficial ownership? Well, the big one is intention. What was the intention? If you buy a condo for your son because property values are so high today, you want your son to be able to get into real estate when he's 18, 10 years from now, it may be your intent to have the condo as being beneficially owned by him, truly owned by him. But it may be that you put the condo in his name to keep it from your wife, and that's different. Beneficial ownership depends on a lot of things. What the intention is of the parties, who paid for it, who's keeping it up, who's paying the taxes. Right? I have a case now, hotly contested case in court. The home is in mother-in-law's name. Wife says, beneficially, it's my mother's. Therefore, I don't have to include it on my assets, and my husband doesn't get half of it through equalization. My client, the husband, says, hogwash. Right? Even though mother-in-law's name is the legal owner, the intention was always that it was the wife's. And she is the beneficial owner, and therefore it should go on her side of the ledger, and I get half through equalization. Complicated stuff. What is not property? Pretty straightforward. income is not property, and there's been plenty of cases out there about whether severance payments, disability income, all these sorts of things are property or not property. Generally not property. And generally, and I think you probably know this, courts try to avoid the concept of double dipping or getting hit twice with an asset being included for purposes of equalization, and then when it comes into your hands as income, using that money to pay spousal support. This frequently comes into play when we deal with pensions. So just a side little point, watch out for that. I think I already covered number 9, how the equalization payment is made. Check. Can make it in installment payments, even up to 10 years according to the law, though you don't see that too often. Typically it's made by share of one person's proceeds from the matrimonial home, and there's no tax on an equalization payment, very different from spousal support.
Even if it's made in installments over 10 years?
No tax. You rarely, by the way, ever see an equalization payment made over 10 years. It's just people will work hard to avoid that because a lot can happen over 10 years, especially with the change in law with regard to pensions. So I don't want to confuse you, but a few years ago they changed the law about pensions in terms of how they're valued. And one of the changes they made was to make it so that whatever the pension is worth, some of the pension can be used to satisfy an equalization payment. So let's say the equalization payment is $10K. Often, if there's a defined benefit pension, which is the kind of pension you see with nurses, teachers, firefighters, police officers, some of that pension can be used to satisfy the equalization payment.
So what if they have to sell stock, though, in order to create the equalization payment? That would be taxable, wouldn't it?
The equalization payment is not taxable, but you raise a good point, which comes up later, which is notional disposition costs. So certain assets, you put the value of the asset down on the ledger, but then when it comes to the debts, right, we're talking about net worth, your assets and debts at date of marriage and date of separation. We typically, a good lawyer will include as a debt on the date of separation what they call notional costs of disposition. The likely cost you're going to incur to dispose of that asset, right? If I have a house worth $1 million, it's not really going to get me $1 million if I sell it on the open market because I'm going to have to pay an agent, right? So typically we'll put a notional cost of disposition. Certain things there are no costs of disposition, a TFSA for example. If you are entitled to a capital gains exemption, no notional cost of disposition. But typically you'll see in the debt section, good lawyers will put in 25% notional disposition costs RSPs. You ever seen that on a net family property statement? And sometimes people put in 35%. So if you're in a high income tax bracket and you expect to be in an high income tax bracket when you retire, when you have to take your RSP into a RIF, it could be more than 25%. We don't know. Typically we use 25%. Pensions too, capital gains on stocks. So that's where it would come in.
Okay, so am I correct then with the stocks that they did technically pay the tax, but it was also a deduction on their side of the spreadsheet?
Wouldn't be a
To
deduction.
offset it.
A deduction is something we're going to talk about at date of marriage.
Well, the notional tax, though,
That would be an
was-
item you'd put in on the date of separation.
So it's a wash. Okay.
It depends what the value is. And people like to fight about what the percentages are. And the higher the asset, the higher the figure included for notional cost of disposition, the more likely you're going to need an expert. And when I say an expert, the kind of expert, I know you guys are experts in many of what you do, but the kind of experts that the courts will want to hear from is a CBV, Chartered Business Valuator. So often on my cases, as part of our team, client has a divorce coach, divorce specialist, someone in your field. They have me, they may have a family member, and they will often have a CBV for complicated valuation issues, this being one of them. Any questions so far? Am I going too fast, too slow? Let's talk about deductions. So when you hear family law lawyers talk about deductions, we're talking about the date of marriage stuff. What is it at the date of marriage that you are entitled to claim? Because now you know it's all about the increase. So it's all about what you came into the marriage with. And it's all about proof when it comes to deductions. You have to have the proof. Unless the other side is very copacetic, cool, agreeable. Long-term marriages, people often don't have the proof. But in a collaborative setting, often people say, you know what, I don't need the proof. I remember that when we got married, you had an RSP worth $50K. No problem. It just goes in as a deduction on that date. Don't forget, even an RSP at the date of marriage has notional disposition costs. People often forget that. So deductions are simply things that you own or things that you owe on the date of marriage. Very simple. The onus of proof is on the person who's claiming it. Remember, it's the opposite to real life. In real life, you don't want to have a lot of assets at marriage. You want to have a nice big gain. Here, the more you have at marriage, the better, because it narrows the gap between what you had at marriage and what you have at separation. So it's obviously the onus is on you to prove that you had it. And often we bump up against the realities of life, that banks don't keep records for more than 6-7 years. So you have to be creative sometimes in terms of how you get that proof. Brian.
If someone claims an inheritance of $1 million coming into a marriage, and at the dissolution of marriage says, I spent it all, what kind of proof is required at that point?
So lots of questions there, and we're going to get to inheritance in a minute. But if the person inherited the money before marriage, right, then it would be up to them to show where the inheritance was at marriage. So let's say a year before marriage they inherit $1 million, $200,000 is spent, and then at marriage they had $800,000. The onus would be on them to show where the $800,000 was at marriage. Then, at separation, if there was no money there, if it was all gone, it's gone. So, good for them, bad for the spouse.
What kind of proof is required for them to say that it's gone?
Well, you can't prove a negative, right? But if the other side says, no, it's not gone, I know it's in an RBC account at the corner, then you'll be expected to cooperate to say, no, there isn't. So, sign an authorization so that the other lawyer can go to the bank and say, look, we believe this person had an account at date of separation with a lot of money in it. They say they have no account. Here's an authorization from them allowing me as the wife's lawyer to go, and the bank will search the records and spit you back a report saying these are all the accounts we have for this person at the date of separation. Here's the records. But if the person had nothing at separation because it was all blown on whatever, then nothing goes in there at date of separation. It's a weird thing, equalization, in the sense that it penalizes the person who saves. It penalizes the person who is responsible. And you'll see, we're going to get to an example at the end if we have time, so I can really test how well you've had this all sink in. And you'll see in the example, it hurts the person who saves. Linda.
In Brian's example, though, if they kept their inheritance money in their own name, it really wouldn't matter whether they blew it or not, because it wouldn't count, right?
Correct. So if at separation, and we're jumping ahead to exclusions, but one of the most popular and highly fought over exclusions is inheritance. And so we'll get to that in a minute. But if you have an inheritance at the date of separation, it doesn't matter how much it increased. It doesn't matter what its value is. It's excluded. But first, let's cover deductions. I want to make sure you...
In the same way that you were alluding to?
Why don't we just get to number 12 first, because I don't want to forget about the home.
Okay, sorry.
That's okay. Question. You all want to talk about exclusions, eh? No one cares about the deductions. 4 simple deductions. But it's number 12, this deduction, that winds up biting people the most. Okay? Does anyone know what I'm talking about when it says deductions at home? Has anyone had experience with this? It's horrible, horrible, horrible.
Where you get married and you move into your spouse's home.
Yeah.
It then becomes 50% yours, and say the marriage doesn't last 3 years, and then you can technically get 50% of the value of that house.
Close. Close, 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 close. Okay, so...
Well, pretty much you lose this exclusion deduction.
Pardon?
You will pretty much lose this deduction if you still live in this home on the day of
Very good. Okay, so let's unpack that. That's good. So, as you heard me explain, it's really about the increase from marriage to separation for pretty much everything. Well, I lied. There's one exception to this rule. And the rule is that if at separation you're living in a home that one person owns, and at marriage the same person owned the same home, you don't just look at the increase. Why? There's no good reason. A lot of people think it was a drafting error, and it's been challenged a few times because it really makes no sense. Other people think it was absolutely brilliant part of the legislation to protect non-titled spouses, most of whom were women at the time that the legislation was drafted in 1985. It's the biggest reason why lawyers like me spend a lot of time doing prenups and cohabitation agreements so that people who get married can protect the equity in the home at the date of marriage, because it's very strange. So let's unpack this. If at marriage you live in a condo and the condo has $200,000 of equity, and at separation you don't have the condo anymore, that money is in a different home that you own, you're going to get the deduction for the condo at the date of marriage, because the condo is not a matrimonial home. Definition of a matrimonial home, also something you can add value with, often something that people really confuse. Matrimonial home is the home that the parties were ordinarily residing in at separation. So you're not going to have a matrimonial home at date of marriage and a matrimonial home at separation, because the definition of a matrimonial home is the home you're living in at separation. You can have more than one mat home, by the way, just to confuse you, but it has to be at separation. So the condo that you had at marriage is not a mat home if at separation you don't have it anymore. But if you had the condo at marriage and you have the same condo at separation, let's say at marriage, as I said, it's worth $200,000, and let's say at separation it's worth $500,000. You say, fine, Braham, you just explained to me that you just calculate the difference. I get it, $300,000 from $200,000 to $500,000. $300,000, I wind up sharing through equalization half, $150,000, right? We now know you don't take the condo and chop it in half, right? The other spouse does not become 50% owner. But as I said, I lied. So when it comes to a property that was a mat home, that's a mat home at separation, and one person owned that home on date of marriage, instead of going from $200,000 to $500,000, you go from 0 to $500,000. So the other spouse winds up getting $250,000 through equalization. Notice I keep saying through equalization because there could have been other assets and debts that accumulated along the way, and there's no guarantee of who's going to pay who at the end of the day. That's why when people come to me and they've got it all mapped out because they've seen a mediator or did some research on the side and they said, I think I'm entitled to this much spousal support and we're going to split the home equally, I always say, well, have you calculated the equalization payment? What? What's equalization? You know, that's the first thing you really need to do before you can agree on how the proceeds of the home are going to be divided. Because let's say the house is in joint names, and let's say there's no mortgage. It's possible that one person's entire share of the house is going to be used to satisfy the equalization payment. So before you agree on sharing those proceeds, make sure you first clarify what the equalization payment is. Question?
Yes. So just to clarify this, when you talked about legal versus beneficial.
Yeah.
And so you bought the home for
Bought
your
the-
son.
Yes.
And but it really was their home with the intention. So
The kid's home.
The wife declares it's their marital home.
Yeah.
If you held the mortgage on that house.
Yep.
So the home is still the matrimonial home, but the son still, like, there's still a debt there that has to be paid.
Yeah, but it's possible. Like I have 2 cases right now where because of spiraling real estate values in Toronto, the husband and wife can't agree on the color of the sky, but they both agree that this condo that's under construction is neither of theirs and it's for their kids. So even though the husband, in your example, may be paying the debt, the mortgage on it, that's not the only thing. You'd have to look at all of the indicia in total to see who is the beneficial
Right,
owner.
but what I'm saying is the divorced couple still owes that money to the parent. So
Divorced couple owes it to the parent.
the parent bought the house.
The parent bought the house, yes.
Yes, and so now they're going to equalize things. They have the matrimonial home.
Well, if the parent owes...
They still both owe half of that debt to the parent.
I don't know in your example who signed the mortgage. It could be just the titled spouse owes the mortgage, but I'm a little confused by your example. But if at marriage the home was beneficially owned by the in-laws, then it wouldn't be on either party's side of the ledger. Think back to my example I mentioned earlier where my client is trying to allege that the home, which is in the titled name of the in-laws, is really his wife's. Right? She says it's not mine. It appears nowhere on my calculations, but on our client's calculations, it appears very prominently as an asset on her side of the ledger. Yes, if there's any debt on it, it would be the wife's debt as well. Can't have one without the other. Okay? I had a case just last week in mediation. And if you really find these small stories boring, I will skip right over them. But most of the time, people want to hear a little kind of juicy gossip. But I had a case last week where I mediated a case. Been going on for 2 years. I frequently get cases where people are exhausted. They're nearing the finish line in court. They both have lawyers. They're on their third lawyer, and they just want it to end. So I'm the recipient often of these very unhappy people who come in. I put them in separate rooms, and I spend like 7 hours with them. And by the end of the day, most of the time, not always, they leave with a handshake and a hug and a signed agreement. That's what I am asked to do. So I had a case where just this point. So for settlement purposes, the husband was prepared to say to the wife, you know what, that house, we're not going to include it in the calculations. I will agree for purposes of mediation today with Braham Siegeal that really this house is your mom's. So I'm not going to share in the increase. Wife was like, oh, that's great. That's so nice of you. It's the only nice thing she said all day. Well, it came time to the date of separation debts. Wife puts in $150,000 of debt. So I look around, I whirl on her, I said, what are you doing? You're sucking and blowing at the same time. She says, well, I owe my mom that money. I said, you just said it's your, I said 20 minutes ago, you said this asset is your mom's. You can't, say I don't have any share of the asset, and then when it comes to the debt, say I'm responsible for the debt when you say you have no interest in the home. Well, it's just that. I said, no, there's no just that. She was very upset.
Now you know why they got divorced.
In the end, she did not get that deduction.
So that's
You can't suck and blow at the same time.
exactly what I was asking.
In Yiddish, we call that being a chazer, if anyone knows what that is. Yes?
Is there case law around if it's a short marriage and that home?
Yes, and we're going to get to that. We're going to get to that. Any questions about deductions? Shall we move on to exclusions, what they are? Yes?
What about like a cottage?
Okay.
Let's say the person had a cottage.
Yes?
Fairly inexpensive, but over the years they were married.
Yes?
They used the cottage as a family.
Yes.
For 15 years or 20 years of marriage.
Excellent.
Still have the cottage.
Yep.
It's now worth $2 million.
Okay, so let's talk about that. First of all, cottage is no different than any other asset. Okay, you first have to look at the difference between who really owns it, beneficial and legal. So let's say the cottage is just in the husband's name. Okay, so he's the titled owner. Let's say the cottage was just used by him. Let's say he's a writer, and let's say he just used it to write. He would go up there and write, and family never used it. Versus a cottage where the family used it year-round. What difference does that make in the calculations? Okay? So it makes very little difference in the calculations because it's his asset at separation. We know that. Okay? Where it comes into play is whether or not it's a matrimonial home. So a cottage that's a matrimonial home is a little different than a cottage that's not a matrimonial home. How? First of all, if he owned it at marriage, we know that he's not going to get the deduction for what it was worth at marriage. So that's one way it hurts him if it's a mat home. But there's a second thing. The definition of a mat home, as you now know, is the home that you were living in at separation. But there are 3 things that flow from something being a mat home, and you should all of you should know what those 3 things are. What are they? Who wants to give me one? If something's in a matrimonial home, there are 3 important consequences. Who wants to give me one? Please. Something you cannot do if something's a mat home.
Sell it.
Good. If something's a mat home, you can't sell it. So even if my home is in my wife's name, she cannot sell it without my permission if it's a matrimonial home. If it's her own investment property, a condo that she owns, we never lived in, she can sell it after separation anytime. Second thing that flows if something's a mat home, mortgage, meaning you can't put a new debt against it without the spouse's consent. So if there's a line of credit against the home, secured line of credit, every second case I have, parties have a mortgage and a secured line of credit that's almost maxed out, almost every second case I have. Because people think property values are going to continue to rise to the end of time, so might as well take more debt out and spend it on trips and cruises and all that fun stuff. We'll see what happens in 10 years. I don't know. So any debt that you currently have against the home, someone can run it up. So if there's $50,000 available on a line of credit, one person go to the bank and say, I'd like all 50K out. So as a divorce financial specialist, it's a good idea for you to check out what the maximum is. And I always advise the client, I said, look, I'm not a financial expert. I don't know your spouse, but you may want to go to the bank and put a freeze on it. Because if one person goes and takes it all out, the bank is only too happy to let them do so. but you can't put a new debt against it. And I think that's what you're referring to. Can't take a new mortgage, new line of credit, and register it against the house. So if someone wants to hire a very expensive, aggressive divorce lawyer, they'll have to do that on their own money or use their own personal line of credit to do it. They can't use the equity on a new debt against the home to do it. Third thing that flows from something being a matrimonial home, yes? Close. You can't kick the other spouse out. Very close. So a lot of my cases, by the time people come to me, someone has left or someone's been arrested or kicked out, and it's not really an issue. But often, in a lot of cases I do, both parties are in the home, someone wants the other person to leave, and they say, well, my wife told me I have to leave because the house is in her name. No, false. If it's a matrimonial home, meaning the place that you were ordinarily living at the date of separation, neither spouse has the right to kick the other out. And most police officers, thankfully, most of them know this. So they will not kick someone out unless there's been a crime. Yep.
So technically they can have 2 or 3 matrimonial homes.
Correct.
Vacation homes.
Correct. As long as they were ordinarily used as family residence at the date of separation. Okay, exclusions. Exclusions are things, assets, that are owned by one party at separation that you have to include. You have to show the value, but then they come out. They're excluded. So they really make no difference in terms of the equalization payment at the end of the day. Equal exclusions are a list. There's a list of them in the Family Law Act, Section 4. And of course, as I was about to tell you what they are, the computer magically signed off. Don't worry, I do know them off by heart. You would think after 23 years. Okay.
We're going to test you now before you turn it on.
Okay. This is why I never like using
Yeah, yeah.
Try password.
I think I have to sign back in. What a drag that is. I think I have to always like connect it a bit. Touch it so that it doesn't log off. So the most common exclusions are, I'm just making sure it's connecting here. And this is not, I'm not really keeping this up for myself. It's just that at the end we're going to play a little game to determine equalization. I don't want to lose it. So the most common exclusions, does anyone know what they are? RESP, that's not really an exclusion. That's not an asset though. So an RESP is an asset that belongs to the kid. So that it's not set out in the legislation as an exclusion. Anyone else want to shoot for an exclusion? Okay, so an inheritance, if this was a law school exam, would get you half marks. That would get you 3/4 of a mark. So inheritance, it has to be something you inherited or gifted from a third person during the marriage. Okay? Gift or inheritance received during the marriage. So someone is gifted some shares in Apple. 2 days after marriage, those shares increase 4-fold, 5-fold over the course of the marriage. At separation, the shares are worth way more. The increase is simply excluded.
Because if that gift, especially when it's a gift, I've been counting this a couple times now.
Yes?
Even the lawyers seem to be confused, but,
Lawyers confused?
well, in this case, it was.
Yes? Well, don't give me a super confusing case that's going to take 10 hours to unpack.
No, but the gift had no direct, there was no deed of gift, there was nothing that specifically said.
Yes.
You're getting $100 today.
Yes.
And any growth in this investment is preserved for the sole benefit of the.
Don't-
There's nothing there.
Don't have to say that. The law says that.
No, but then if you get a gift today and it increases 100-fold, why can you as a spouse not share from the increase?
Section 4 of the Family Law. That's what. So if my father gifts me some shares in Apple or shares in his company, and they're worth X dollars the day after marriage, and by marriage and by separation they're worth way more, the way more part is excluded. Unless you have a prenup.
As long as you don't sell them
Okay, so let's just make sure we understand what the exclusions are, and then we'll talk about how to lose them. So other exclusions are personal injury, if you get money, settlement from a personal injury, life insurance. Those are the big exclusions. Okay? Now, there are a couple of tricky parts here to exclusions, which people don't get in their 3-minute primers, but you guys are going to get. If you inherit or are gifted money or property during the marriage, and you stick it into a property that's like a condo that's used on the side that you rent out, that's okay. At separation, you can trace your inheritance, your exclusion, to an asset. That's okay. You will be able to get the exclusion.
Even if the property is in joint name?
If it's in joint names, you'll probably be able to exclude half, because you have to own the asset at separation. So if you and your spouse own it, you only own half. I'm simplifying things a bit. There have been cases that say some different things, but in general, that's safe to assume. But if you inherit or are gifted money or property during the marriage, and at separation it's found its way into the mat home, what happens to your exclusion? Gone, unless you have a, right, which in Canada is called a, very good. So it's one of the big reasons people do a marriage contract, because a couple is young, but they know that someone along the line is going to inherit a lot of money, and chances are, Toronto area being what it is, they're going to need that money to buy a home, which may be a matrimonial home when they separate. So if you want to be able to exclude that out, give it back to the person who got it, you need a marriage contract. Otherwise, you lose that exclusion. Yes? Well, let's see how the first one goes before I decide on the second one. I'm a little nervous with you.
Okay. What about engagement rings that, I think that's a gift.
Okay, so
And yet
engagement
we have
rings,
them.
very simple. This comes up all the time. Engagement ring is a gift, but it's also an asset that you have at marriage. The other thing about engagement rings is they rarely increase in value. So I always tell my clients, don't worry about it. They all get very nervous when I ask them, what was the value of your engagement ring on the date of marriage, and what is it, what was it at date of marriage? They frequently give me a low figure. I said, it doesn't matter. You don't have to be nervous, because the chances are it did increase in value, and you had it at marriage and you have it at separation. So there's not going to be any increase, and it's a gift. Engagement rings are gifts. You don't have to return them. Although my assistant who recently got engaged, and maybe 2 days after they got engaged it all fell apart, I keep telling her, morally, you should be giving the engagement ring back. She doesn't want to hear from me on that. Yeah?
I've heard often jewelry actually goes down in value, appreciates like crazy. Seriously, you bring $10,000 for something,
Not these
sell it
days.
for $10,000 worth year later.
That's a bit of a,
You wouldn't allow this to lower the...
the flip, no. Engagement rings, we rarely, judges, I'm in court 3, 4, 5 times a week. Judges really don't want to deal with contents and jewelry, things like that, and they typically will say jewelry does not increase in value. But what happens sometimes is people will pull up the appraised value from the insurer, which is usually way more than the husband paid for it, and you can get all kinds of fun and games with that. Wife says, no, you told me you only paid $10K. And he pulls up the certificate and says, yes, but, you got it insured for $40K. And she says, but that's just the insurance. You can have all kinds of fun and games with that. But it is a gift. You don't have to return it, and typically doesn't increase in value. Second question.
Okay, I win the lottery OLG third party.
Good for you.
Yeah.
It's not a gift. It's not an inheritance.
But is it excluded?
Lottery winnings as excluded. Well, I don't know. I guess you could argue it's a gift. I wonder if this has actually been litigated.
Does it matter that I bought out of the joint?
Yes. Yes, it could. Yeah, and I had this come up.
Yeah.
So typically, I think that it would be a very good argument that it's a gift, and if the ticket was bought from a joint account, the other side would argue that they are entitled to half of the lottery winnings. But remember, it's all about where the lottery winnings are at separation. So if the couple is irresponsible, and by separation all the lottery winnings are blown, then there's no issue there.
If I use my inheritance to buy a lottery ticket and I win the lottery.
Traceable. That's something called, that's traceable, right? Because anything that you can trace to an excluded asset is excluded, and we'll get to that in a minute. In fact, it's right here, tracing. Yes, question?
Can you do a marriage contract after you do marriage?
Yes. You know what it's called? Marriage contract. Yes? Yes, Ms. Fowler.
Can you speak more to the life insurance exclusion? If it's a whole life with a large cash value, or a universal life that has a side account with very large.
No, no, no,
There's
no.
all sorts of different life insurance, and I find that really confuses.
Very
not
simply.
just people, lawyers in general.
You're confusing two concepts. So let's talk.
It's the death benefit, not the
No, I
cash.
know, that's what I'm
Right.
saying. That's
So
what I'm saying.
at separation, if someone owns a life insurance policy, if it's a term life policy, ignore it. It may be important for spousal support to secure spousal support, but if it's just a term policy, it has no value for equalization because it only pays out if someone's dead.
Exactly.
Thank you.
You're going to-
I should have you up here, kind of.
No.
There you go.
You can't afford me. I can't afford you, you can't afford me.
I always tell people that I'm getting so expensive I can't even afford to talk to myself anymore. My wife finds that highly obnoxious, so don't. So life insurance, if it's a term policy, no, it just pays a death benefit, no value for purposes of equalization. If it's a whole life policy, it's like an RSP. It has what they call a cash surrender value. That's the figure you need to circle that goes in the calculations. Exclusions, what we're talking about exclusions, is if someone receives a death benefit. Okay, and again, if it doesn't go into the mat home, let's say you get a $100,000 life insurance policy paid out to you from a family member, and you've still got it in a bank account at separation, that's a tracing issue, right? And then you have good tracing, and it is excluded.
Bonnie, don't forget, in that situation, to include the cost of disposition
Oh,
of
absolutely.
the ACB.
I'm working on a case right now where the other party is using this, telling me that life insurance is an exclusion. I said, no, it's not. There's tax value sitting there. It's not.
Depends what kind of, it's a whole life policy?
It's a universal life.
Yeah, that's a whole life policy.
That's not
Same thing.
exclusion.
No.
Somewhere they've got something from somebody who seems to think that it is because they're lumping all of that under life insurance.
Each of you should have a good certified specialist family law lawyer that you can call, email, or contact when lawyers either try to pull one on you because you're not a lawyer, which happens all the time, or the lawyer just doesn't know. Dealing with an inexperienced lawyer, or a lawyer who's young, or whatever. Tracing is a big issue in family law when it comes to, sorry, did you have a question before we got to tracing? Go ahead.
Well, it's kind of tracing. You get that gift of the shares of something that is grown a lot.
Yeah.
And if you kept it totally separate, I get that. It had no dividends. But what it had lots of dividends over the years that you were using to support your family, to
Right.
buy the extra holidays, etc. How does that affect?
No, if the shares threw off dividends and the money from the dividends is no longer there at separation because it was used for the family, that's not.
But it doesn't go back to the asset as that
No.
you used it as part
No,
of it.
no. It's first of all, what is in existence at separation? So in separation, if it's just the shares that are there and you own them, then the value of the shares has to be listed, but it's going to be excluded. The increase is going to be excluded.
The dividends would likely be included for support, though.
It depends on what year. If the dividends came into income, 10 years ago, but aren't there,
But if it's a regular dividend, then that's a different story.
Absolutely. Absolutely. So tracing is a big issue, right? It's not just about the exclusion you have, but if you can trace any asset into an asset that it came from, that's a traceable asset. And we spend a lot of time and money for people trying to trace assets. So let's say during the marriage, I inherit $50,000. I use that $50,000 to buy a piece of art. The piece of art is worth $75,000 at separation. That's a tracing issue, right? Because I can trace the money into the piece of art, and the piece of art is going to be excluded for how much? 75, because that's the value of the asset at separation. It gets complicated when people commingle, right? So they inherit $50,000, they buy a piece of art for, say, 75, but 50,000 of the purchase price came from their inheritance, and 10,000 came from a loan, and 10,000 came from their spouse, and 5,000 came from their savings account. What do you do at separation when that asset is 100K? Most of the time the answer is pro rata, proportional. So at the time of purchase, if, say, 50% of the purchase price was from inherited monies, most reasonable, good lawyers and judges will say, whatever that value at separation, give him an exclusion or her an exclusion for 50%. Some lawyers will be real jerks and say, sorry, if all the money's commingled and at separation you really can't see in this bank account how much is clearly traceable, you lose it all. Question?
With regards to inheritances, if it's inherited in advance of the marriage, then it's a deduction.
Very good.
And
So
if it's inherited during the marriage, it's an exclusion.
only if they have it at separation. But if I inherit money before the marriage, and I have that money at marriage, then it's going to be a deduction, meaning I get credit for the full amount at marriage. Correct.
Okay. Now, again, going back to the same situation I'm thinking of, date of separation, they're claiming that there's nothing. However, the spouse believes that it's been hidden.
Yes.
The proof is on who to trace it and show that it's been hidden.
Well, the spouse that wants the asset there at separation is going to be the one that's going to have to carry the ball down the field and say, show me proof of this, show me proof of this, show me proof of this. And the other side is going to be expected to cooperate to a reasonable degree. As I said, you can't prove something that doesn't exist. But if one person says, I think that you had it in one of these bank accounts, and I would like your cooperation to see if that's true, then the other side's expected to cooperate.
And if the other side doesn't cooperate, then...
That's why they have judges.
Run them over with the car.
What's that?
Run them over with the
Run
car.
them over with the car?
You know me, Brian.
Okay, some interesting wrinkles here. How are we doing on time? Really? That's so bad. Okay, interesting wrinkles. Post-separation increase not relevant, mat home, joint versus sole ownership. Okay, so one of the things that typically happens during a marriage, especially when the higher earning spouse is self-employed, is they put the matrimonial home, or at least the home that eventually becomes the matrimonial home, you now understand why I'm saying that, into the non-titled spouse's name. Okay, my own situation is very akin to this as well. I'm a lawyer, we have 10 people at our law firm, my house is in my wife's name. You might say, and so the question is, so what? And if you were paying attention for the past hour, you might say, who cares? You just told me that regardless of whose name it's in, it goes on one person's side, and the other person has to make a big equalization payment. So if the home is in Braham Siegel's wife's name, she's going to wind up making a big payment to him of half through equalization. So what's the wrinkle? Well, the wrinkle is, of course, post-separation increases. Assets, particularly real estate, increase a lot after separation in this day and age. And if the house was beneficially owned by my wife, meaning truly owned by her, any increase in that asset, like any increase in her RSP or life insurance policy, would inure only to her. Whereas if the asset was joint, both of us would share in that post-separation increase. So you can tell a lot about a lawyer or a file or a client right off the bat when you ask them, why was this house put into one person's name? And the minute that the words creditor proofing come out of their mouth, well, it was done to protect from creditors or potential creditors, you know that this is something to watch out for. If one person claims that beneficially the house is in the non-titled spouse's name and is meant to be for the non-titled spouse, you got a problem. Because your client may be denied the post-separation increase. So the first thing I do when I'm representing, I won't say powerful men, but it's usually the men who put the property in the women's name, I always ask the other lawyer, as soon as we sit down for a settled meeting, this home, even though it's in your client's name, she's agreeing, right, that beneficially it's joint? It's the first thing I always ask, because I want to make sure my client's going to get equal share of the post-separation increase. Yep.
In doing preparatory work with younger couples,
Yep.
putting the house into a spouse's name, is there a document that can then eliminate the issue in the event of a marital breakdown?
Marriage contract.
Marriage contract?
Right. So you could put in a marriage contract, you can say that regardless of whose name a home is, if it's a matrimonial home at separation, it's going to be treated as beneficially joint. My own marriage contract says that. Look how much you're learning about me. I'm learning nothing about you. You're learning all this personal stuff about me. But that's what my marriage contract says. Interesting wrinkles, pensions, how it used to be, how it is. I'm going to do this pretty quickly because I want to get to our fun exercise.
Actually, half an hour, you're good.
Oh, am I? Okay, good. So pension, as we understand, I'm looking at you because you mentioned that you do pensions, so I'm looking at you. So the way it used to work with pensions, as you know, they're property like anything else. They have to be valued. Certain pensions are easy to value. Defined contribution pensions, that's what they're called, DC pensions, are like RSPs. They're easy to value. You get a statement. Defined benefit contributions, I mentioned them earlier, I believe. Firefighter pensions, nurses' pensions, police pensions have to be valued according to the law and a series of complicated forms. The lawyer will, or a clerk will fill them out, send them in. The pension comes back in a report. And the report says, this is the increase. Nice and easy. Before the change in law, anyone know when the change in law came in? I'm looking at you. January 1st, 2012. Before January 1st, 2012, you would go to a valuator and you would give him some info and the valuator would do a report and lawyers would fight about what the value is because the valuator would give 3 different options based on different retirement dates, and we had a lot of fun in court fighting about that because during marriage, husband would always say to the wife, honey, I plan to retire Freedom 55 as soon as I can. Report comes in after they're separated, and of course that's always the highest value because when you retire at 55, the pension gets paid out longer than if you retire at 75. So a husband, of course, after separation says, no, I want to use the smallest value, right, for equalization. Remember the opposite of real life. And the wife says, you bastard, you said during the marriage you want to retire at 55. Now you're saying you retire at 75. So the new law, January 1st, 2012, gets rid of all that. One number, everyone's bound by it, and the law says that every pension administrator has to use the same formula. So it's wonderful. The law also, and I mentioned this earlier, now allows that whatever the equalization payment, not just the pension, but whatever the global equalization payment, you can use up to 50% of the pension to satisfy the equalization payment. This is actually a wonderful, and I'm not being facetious, sarcastic, a wonderful improvement to the law, because before this, we typically had a situation where the parties only had a home, say joint names, and the husband had a pension. And because he couldn't sell the pension, had to make a big equalization payment as a result, there was no way for him to make the equalization payment other than transfer his share of the house. So we had a lot of guys living in basements with craft dinners because the only way to satisfy the equalization payment was to transfer his share of the house. Now with this change since January 1, 2012, you can satisfy the equalization but actually transferring a chunk of the pension into a lira, locked-in retirement account for the other spouse.
Federal pensions, because you were talking about provincial ones.
Not too much other than some of the federal pensions use the Ontario formula. So if you're not sure what they do, you need to consult with a pension valuator. So they are still around, and I will contact them if something like a CN Rail one I had recently where they will still follow the Ontario law even though it's federal, but sometimes it's very different. So the minute you hear federal pension, you got to ask yourself, do they follow the Ontario scheme or not? And if you're not sure, go to a pension valuator, an actuary, pension actuary. Number 20, debts to family members, very quickly. Because it's the opposite of real life with property and equalization, people are incentivized to have a lot of debt at separation. So we frequently see debts which some people think are manufactured, exaggerated, which appear on people's financial statements as debts to family members. And the other spouse, typically my client, says, I never heard about any such debts during the marriage, and here on a financial statement there's a $100,000 debt to mother or father. So judges don't look very kindly on these, you should know, and you should only put them on a client's financial statement if you have really solid proof. When I say solid proof, a promissory note or a debt instrument created at the time the money was advanced, not after the person saw their lawyer. And even in certain cases where someone does have good proof, promissory note created at the time, judges often will take a bit of a razor to the debt and give it a bit of a haircut based on the anticipated likelihood of this debt being repaid. So if, for example, your client's brother also was loaned money by the parents and that brother's debt was forgiven or only had to pay back half, that's something a judge might use to cut. Someone earlier asked about if the marriage is less than, I think someone asked if the marriage is 3 years. Thank you, Bronwyn. So I'm not going to spend a lot of time on it, but the equalization payment rules that I gave you are a formula. Very, very strict formula, and it's very hard to get out of. The only way you can get out of an equalization payment is if there has been what they call unconscionability. Unconscionability is a lot more than just unfair. It means shocking to the conscience. So it's a very high standard. You should make sure your clients understand that so they don't think they can easily walk out of their equalization obligations. should have just printed it off and handed it out. Problem is I created this at 7 in the morning. Typically, if, without getting into too much detail, because when you're meeting clients for the first time, you don't want to bombard them with too much detail. Unconscionability is if someone has, for example, committed a ridiculous act where they've depleted all their property right prior to separation in order to deprive the other side of their equalization payment. Or conversely, racked up a ton of debt in order to make it so they have no increase. Some people will do this, cut off your nose to spite your face sort of thing. They're stuck with all the debt, but they don't have to make a big equalization payment. That is something that can be labeled as unconscionable. The most popular circumstance where unconscionability exists is marriages. It's not marriages, but cohabitation of less than 5 years. If you have a situation, and by the way, people call this often the gold diggers provision. If you have a situation where parties have cohabited for less than 5 years, that can give rise to an unconscionability claim. And typically, let's say it's a 3-year cohabitation. So 3 out of 5 years is 60%. A nice rule of thumb, or a nice way to settle cases, is if the cohabitation was 3 out of 5, that's 60%, for those of you doing math. So whatever the equalization payment is, let's say the equalization payment is $1 million, as I just had on a case last week, the judge might recommend $600,000. Okay? By the way, my client got her full equalization payment, but squabbled about the $20,000 adjustment. Shall we do a little example to see what you've learned? Okay, here are some facts. This should be fun. Well, at least for me. Here are some facts. You're going to take all of these. You're going to try and see if you... I'm just trying to get it all to line up nicely. There we go. So you can write these down or just kind of go from here. But what I want you to do is I want you to try and calculate the equalization payment. And anyone who can correctly calculate the equalization payment, you'll notice I've thrown in some wrinkles, gets a free consultation. God forbid if you ever need one. So I'm going to read it over to you. I'm going to give you 5 minutes to try and calculate the equalization payment. Then I'm going to go through the answer and give you the equalization payment, and we'll see who got it right. No cheating. So at separation, husband had RSP worth $40,000, presently worth $50,000. Cash in a bank of $15,000. A car worth $5,000, which now that he's separated, he's thinking of gifting to his daughter. The car was a gift from his dad during the marriage. At the time of the gift, the car was worth $10,000. He also has a jointly owned home with his wife worth $500,000, with a line of credit for $100,000, which he alone put the down payment on. At separation, husband had a credit card of $7,500 and a personal line of credit of $12,500. Don't worry, I'll put this back up so you can write it down in a minute. He also claims he owed his parents $75,000, and the only proof of this is a promissory note created after he went to see his divorce lawyer. Husband received $75,000 inheritance during the marriage from his aunt, which the parties used to pay down the mortgage on the mat home. At marriage, the husband's RSP is worth $20,000, was worth $20,000. He had a boat worth $8,000, a motorcycle worth $2,500, and CDs worth $1,000. At marriage, he owed his sister $5,000.
You did this at 7 a.m. Poor soul.
Yeah. I do a lot at 7 a.m. It's productive. At separation, the wife had GIC worth $25,000. Now it's gone, spent on legal fees. Wise move. Defined contribution pension worth $100,000. Investment property worth $350 with a mortgage against it for $75,000. Jointly owned home with husband worth $500 with the line of credit against it for $100,000. And some shares in Apple worth $80,000. Nothing else. At marriage, she had a GIC worth $5,000, which was a gift from her parents when she graduated high school, and $20,000 of student loan debt. She also had a joint bank account with her mother, which had $600, which her mother set up for her when she was a baby, and some shares in Apple worth $15,000. During the marriage, the wife inherited $165,000, which she used to buy a condo. She paid cash for it. During the marriage, she then sold the condo and used the money to purchase the investment property owned at separation. During the marriage, the husband earned $140,000. Only he paid the mortgage on the home. The wife earned $60,000. She saved her money and invested it. Go. You want me to put it back to the top? Have fun with it. It'll give you a good idea of how certain things in this calculation are easy and how certain things are hard. And what I suggest you do is just make a list of all of them and then try to see how your calculations go. Ask yourself what's at separation, what's the exclusions, what are the deductions, and see what you can do. By the way, don't get offended if you're taking notes over my picture. I do get offended if you're writing notes to your friend, which is what I only saw one person do. Yeah, do not, thank you. For this, it's confusing enough. No disposition cost. Don't worry about that. No. Yeah, sure. Oh, I forgot this part. That's important. This part right here, I didn't scroll that part. You got that? Yep. Five minutes. But you can lose a lot of money if you don't do it right and get sued. That's the tricky part. What's that? It took 23 years to get to be able to do this in 5 minutes.
It's all theoretical.
So I assume those are the same Apple shares purchased.
Yes. Good question. Did you hear the question? She said, Sharon said, I assumed the Apple shares owned at separation are the same shares that the wife had during the marriage. They weren't kind of sold, and then she had nothing and then got new shares. Shall we start? Okay, so before we start, I want to make sure that we're preventing cheating. So write down your answer. I will come around and see if anyone had the right answer. Okay, does anyone have an answer? Some of you may have just given up. That's cool. That's cool. This is a learning exercise. Does anyone have an answer? Yes? You want me to look at it? You don't want to tell me, because if you're wildly off, then your colleagues will think you're dumb. I get it. Okay. Okay. Not correct, but okay. Good try. At least you tried. Okay. Not correct, but close. Okay. Not correct. Fairly close. Oh, that's the closest so far. Okay. So the answer is 97,950, and my record of no free consultation still stands. Let's go through it, shall we? We're going to go through it. We're going to identify each item. I'm going to show you where the red herrings are. There's a few red herrings here that are just meant to throw you off the trail, and then we're going to calculate it. Okay, at separation, husband had RSPs worth 40,000, but presently worth 50. Where's the red herring there? Who cares what they're worth now? Doesn't matter. You know, people often say, well, he cashed them all. Doesn't matter. It's what things are worth at separation. If he cashed them all 2 days before separation, then we may have an unconscionability problem. Okay? So we're going to list the husband's assets here. He's got the 40,000 of RSP. Cash in the bank of 15,000. Very simple. Not everything is complicated. A car worth 5,000, which now that he's separated, he's thinking of gifting to his daughter. But he's going to gift it to his daughter. It's a red herring. People often will say things because they've done a little research and understand that if it's not beneficially owned by them, it doesn't get included. And, you know, during negotiations, the parties may agree to take out the 5K and put the car into the daughter's name. But that's for negotiations. When the client is sitting in your office, the right thing to do is put the 5,000 down as the car is owned by him. The car was a gift from his dad during marriage, which tells you, what is it? Right. Okay, so whatever the car was, we know he has it at separation, so down here there's going to be an exclusion. At the time of the gift, the car was worth 10,000? Red herring. Who cares? It's all about what the value is at separation. Did you get that? Did everyone know that was a red herring? Okay. Husband has a jointly owned home with wife worth, getting my exercise in here, worth 500,000. So because it's a jointly owned home, it goes down for half. 250, half home. Not because it's a matrimonial home, but because it's joint. That's why it goes down for half. And he's on for half the mortgage. The mortgage is 100,000. So his half, the debt, is 50K. And just so I don't forget, I'll put the 250 down for the wife and her debt of 50K. The husband alone put the down payment on the house. Red herring. Not relevant. Okay? At separation, the husband had a credit card of $7,500 and a personal line of credit of $12,500. So this is his debts right here. $7,500 is the credit card and $12,500 for the line of credit. Those are his debts. He claims he owed his parents $75,000, and the only proof is a promissory note created after he went to see his divorce lawyer. You'll see this all the time, though. People will push you as their professional. You work for me, they'll say. You put this in as my debt. Either you do, and your reputation will suffer when a judge or a lawyer looks at it and says this is garbage, or maybe the client has the proof. If he has the proof and he tells you it was created at the time, not after they went to see you, you can put it down, but if I was you, I would let them know that they're on shaky ground. Right? Promissory note from family members and debts from family members to the spouses are, always looked at with a very skeptical eye. Yes?
Sir, Braham, I think one thing that's important too is that a lot of times when the clients come to us, we get the information, so we're not the lawyer to make the decision.
Correct.
So when we deliver the product to the lawyer, a lot of times it will be annotated so that you understand what the client's place is, and you then ultimately will make the decision, yes, I agree with you or no, I don't, because we're working with them, but we give enough information so that ultimately the decision is really.
Yeah, but it's all about expectations. So by the time the client comes to me, if they've been put on a pedestal, so to speak, by whoever it is, family member, divorce professional, mediator, and been told, I know that I can get this claimed as a debt, then it makes my job harder. Whereas if I know that the divorce professional has told them, chances are you're not going to get credit for the $75K and you're not going to get credit for all of it, you might get credit for some of it, it makes my job so much easier.
But we normally wouldn't put that in a column.
Oh, people put it in columns, all right. Lawyers put it in columns. They kind of figure, while you're at it, might as well let the other lawyer worry about it. Your reputation will suffer. That's at least my view. So I would not put the $75K in. I did not. Yes?
What about though if during the marriage, as a couple, they had been paying the parents back?
Okay, that's a different,
whole, like,
that's a whole different kettle of fish.
Okay, because I haven't heard that part, and I would have put that down.
No, I mean, if I had put in, by the way, the parties made payments right up to separation to the parents from a joint account, that's good evidence of a debt.
Okay, perfect.
Or joint debt. But if what happens is at separation, one person then starts paying the parents off, that's a different story. Husband received $75,000 inheritance during marriage from his aunt, which the parties used to pay down the mortgage, meaning the mortgage on the mat home. What do we do with that? That's an easy one. Sorry? Commingling? Is it commingling? What's that? I can't hear you.
Is it traceable?
It's traceable. The 75 was inherited, but the parties used it to pay the mortgage down on the mat home. Anything, it's not about commingling. Anything that is in a matrimonial home at the date of separation, you lose the exclusion. So that's not about commingling. It's about that it went into a mat home. So if the 75K was used to buy an RSP, and the RSP is now 80K, that would be excluded. Okay, so again, nothing in for that. At marriage, the husband's RSP was worth $20,000. Again, we're not putting in disposition costs here. He had a boat worth $8,000. Motorcycle, $2,500. Any idea why I put the CDs in? No. People don't have CDs anymore. So it's someone might say, well, he had them at marriage but didn't have them at separation. Well, you still get credit for them if they're worth $1,000 at the time. And of course, proving what your CD's worth is not so easy. You'd have to have a lot of CDs to be worth $1,000. And at marriage, he owed his sister $5,000, so that was a debt that he had. I'm asking you to assume that.
I'm assuming you can't claim that the CDs are not worth $1,000 anymore.
You what?
Can you claim the CDs are not worth $1,000 anymore?
He doesn't have the CDs now. No one has CDs anymore, or at least most people don't. Okay, fine. So your CDs, if you still had the CDs at separation, whatever the value is at separation, they may be worth $300, they may be worth, I don't know, collectible items, right? So that's the husband's side. Does everyone's side look like this? That's as simple as that, how it should look. Wife's side, $25,000 in a GIC, now gone, spent on legal fees. What do you do with that? She's stuck with the 25K, right? People will frequently come into you and say things like, after separation, she did this, she did that. Do we need to rush off to court? No. If they had it at separation and you've got good proof of that, they're stuck with it. Doesn't matter what they do with it after. Defined contribution pension worth 100K. Again, if it's a defined contribution, that will come from the pension administrator through the forms that we talked about, and there will be some disposition costs associated with this. Investment property worth $350 with a mortgage against it for $75. So investment property and $75K for the mortgage. This is how you should reflect it. The jointly owned home with the husband, we have that. And some shares in Apple worth $80,000, nothing else. At marriage, she had a GIC worth $5,000. It was a gift from her parents when she graduated high school. What's the significance of that? Excluded, deducted, irrelevant, red herring, don't know, getting tired, bored, bring in the next speaker. Enough already with the marker and the tablets. And
It was before marriage.
so,
Yeah.
deduction. She came into the marriage with it.
Right.
Okay, deduction. Exclusion is something you have at separation that you then factor out. $20,000 of student loan debt. So that's a debt at marriage. Student loan. By the way, can you have negative net worth? Can't have negative. Forgot to mention that. She also had a joint bank account with her mother which had $600. This is the thing that saves me typically from having to give a free consultation. $600, which her mother set up for her when she was a baby, meaning when the child was a baby, not the mother was a baby. So what do you do about that $600? $300. Some people think $300. Anyone have a different idea? Think of legal ownership. So legal ownership versus beneficial ownership. Who says 300? Who says 600? 600. Right? The account was entirely set up for the child's benefit. The money is entirely the child's, meaning the wife's. $600. Shares in Apple worth $15,000. And Sharon, I think it was you that made a very good question. We're assuming the shares are the same. Actually, even if they're not the same, it doesn't matter. If these shares are different than these shares, it doesn't matter because we take a picture in time. So it doesn't really matter. She could have after marriage sold these shares, used them to buy a car, sold the car, bought more shares of Apple, and at separation she has shares in Apple. They don't.
But then wouldn't that be an exclusion?
No. No. This is, she gets credit for the deduction. She had this at marriage. Okay? So it doesn't matter.
But in order for it to be an exclusion of cost.
It ain't an
to
exclusion.
show that it was the same flow of money.
For it to be an exclusion, she has to show that this asset was either gifted to her or inherited during the marriage, which she didn't. She came into the marriage with it. It wasn't during the marriage. During the marriage, the wife inherited $165,000, which she used to buy a condo. She paid cash for it. So what do we do with the condo? You don't put it down because she sold it during the marriage. Think of the picture. She didn't have it at separation, so you don't do anything with the condo. During the marriage, she then sold the condo and used the money to purchase the investment property right here. Okay? So this asset is excluded. She had it at separation. The money that she used to pay for it was received by gift or inheritance during the marriage. So you figure out what the equity is in this property, which I did earlier this morning at $275K. So the investment property, there's an exclusion for her of $275. Did anyone get that? Boy, am I a lousy teacher. Want me to explain that again?
Yes, please.
So at separation, she has this property, but it's excluded. Why? Not because she didn't receive this property as a gift or inheritance during the marriage, but it's traceable. It's a tracing issue. She got money from an inheritance or a gift that she then used to buy this asset. She has it at separation. It's traceable. It's easily traceable. I made it easy. Like, let's say she had used some of the money to buy it, it would have been a lot more complicated. But it's traceable. So whatever the equity in this asset, she can exclude it. So it'll be in and out. Question from some stranger who walked in halfway through. I bet you do.
I do. I'm the estates lawyer, so the 75 still gets to keep that on their side of the...
It'll make no difference. Right? The equity here is 275. The equity here is 275. It'll be a wash. It won't affect the equalization at all. But the proper way on the financial statement to reflect it is asset and then the debt. Final piece. During the marriage, the husband earned $140,000. Only he paid the mortgage on the home. Wife earned $60,000. She saved her money and invested it.
Oh, well.
What did you say? It's irrelevant. It's just a real bitter stake to the heart when wife comes in and says, you know, during the marriage, I was the saver. I was the smart person who invested. He spent it all at the track. Or fill in your appropriate word where he spent it. And it's and then you know what I tell them? I say, well, marriage is a partnership, and that's the way the law works. And if you were very unhappy, you could have separated earlier and avoided all this mess or done a marriage contract. Yeah.
Wouldn't you need somebody forensically to figure out where that money went? Because she's not showing those assets.
Yes, she is. What do you mean, a forensic?
She's been saving 60 grand a year.
There you go.
with her dad and dad.
Well, who knows? Maybe they have 4 kids and they spent it all in private school, right? But yeah, I mean, if you deal with someone who says, you know, my husband had all this money, where did it go? Then you're into a whole different world, asking where did the money go and give me bank statements. And most of the time, the money isn't in a Cayman Islands bank account. There are not too many of those cases around. And most of the time, people just either overspend or don't communicate where they're spending the money during marriage, or they're spending it on their kids or activities and things like that. Okay, this is how it should look for full marks. So, adding things up, you would see husband's increase in here, his assets at separation are $310,000. His debts at separation are $70,000. So At separation, he's worth $240. At marriage, he is worth $31,500 are his assets, minus his debt of $5,000 to the sister. So at marriage, he's worth $26,500. And here's the exclusion. So the math is simply 240 minus 26,500 minus 5. The husband's increase during the marriage is 2085. Did anyone get that? What do we call this in family law, this number? Interloper from the back, what do we call this? NFP. We call this your net family property. It means your increase in your net worth. As lawyers, we like to make lots of complicated legal phrases to confuse everyone who's not a lawyer to justify our high fees. So 208,500 is the NFP. Let's do the wife's. I'm running into other people's time, so I want to move it along. Wife's assets at separation are 805,000. Her debts, 50 plus 75, 125. She is worth, at separation, 680,000. If you got that, give yourself gold star. At marriage, she had 20,600 of assets minus 20,000 of debt. She is worth $600 at marriage, and the exclusion is 275. So 680 minus 600 minus 275 should give you 404,000. So then what you simply, this is her NFP. Okay? So to get the equalization payment, you simply say the wife's NFP of 404 minus the husband's NFP, which we said was 2085. The difference is $195,900. Is this your equalization payment? This is not your equalization payment. This is the gap. Remember an hour ago we learned about the gap? The equalization payment is half of this amount, $97,950. And you can check, and you should check your math to make sure it's right, by saying 97,950 plus 208 gets you 0, 5, 4, 7, 16, 306,450. And if you take away a very painful 97,950 from the wife, you should get the same number. Thank you. That's all you need to know.
Wow, that was great.
Helpful?
Yes.
Giving you some good tips? Enjoy.
Thank you very much.